proceed.
I am.
Go ahead.
May it please the court, my name is Adam Amir, representing Harold Stills. This case is about a fundamental question of fairness. My client went to go purchase a brand new car and was riddled with problems from the start. At the lot, it wouldn't start. He allowed it to be repaired, but when he finally ended up driving it off the lot, it began to dangerously shimmy. So much, and happened so often, he had to bring it 6 different times for it to be repaired. The car is still in a dangerous state, and my client wants to finally retain my counsel to try to take legal action on being sold what appears to be a defective car. But when we contacted opposing counsel, when we contacted this company, we realized they're claiming that they're a new company, despite having, an owner, member of the family of the old company, despite having some of the same salespeople, despite being in the same location. They're claiming they're a new company and they're not liable for the problems that they sold to my client. And it's for this and the following 2 reasons that we urge the denial of the motion for summary judgment. First, a reasonable juror could conclude that Phoenix represents a mere continuation, which under California law would require that they be liable for the debts of a former corporation. And second, we think that there are too many tribal issues of fact in this case, particularly with issues of intent, that should be left for a jury, and that therefore the motion for summary judgment should be denied.
What's an example of that?
Your Honor, the first one, and I think this goes to the question of the different factors under mere continuation, goes to the shareholders and directors that seem to be the same in this second company. We see the old shareholder, Frank Sherwood, is now a majority shareholder in Phoenix. But beyond that, we see that as the defendant's own declaration shows, Frank Sherwood has not only a stock in the corporation, but considerable influence over the new director, which of course is his sister-in-law. He admits that he was able to goad his sister-in-law into hiring 3 of the old salespeople. So it's not as if, as opposing counsel said, this is an entirely different corporation. This is a family business, and we see that there are connections between the old guard, the new guard. It's in the same location. It started off with the same inventory. We think a reasonable juror could conclude that this corporation is a mere continuation. And additionally, there are questions raised about the possible lack of consideration. As Your Honor noticed when my opposing counsel was up here, there are some questions. It seemed that Frank Sherwood and his corporation should have been on notice. It's pretty unusual, I think, and I think a jury could agree that a car has to be returned more than 6 times for repairs. So there could have been a claim out there, because it appears that my client was sold a defective or a lemon car. And so we think that not being part of the deal could affect the consideration question, and that ultimately there are too many doubts both on the question of the shareholders' connection and the consideration that a jury should ultimately decide this question.
Well, what role do you contend is played by the bulk statement notice in this case? You are having notice of some time question. How does that play into some judgment?
Your Honor, I think it's certainly important and it helps opposing counsel's side. It's simply not enough to defeat the role of the matter of questions in this case. Sure, there was a bulk notice. I think, as a matter of fact, few people actually notice these notices, even though it's an ingrained part of our legal system, and we should recognize that. There remain additional questions. I mean, there is an individual in the corporation who's running it. It seems to have a direct line of communication with the old one. I mean, we have they purchased all of the old inventory. There are just too many questions raised about the old corporation being too cozy with the new one, such that a jury could conclude that it's a mere continuation. And that's why we don't believe that summary judgment is appropriate here. But if I may continue, one of the tribal issues of fact that I haven't discussed is really the question of fraud. And now, as Your Honor knows, fraud is one of these questions that is extremely dependent on state of mind and intent. And therefore, it's inappropriate to decide it on the papers here. Fraud inevitably involves making determinations about credibility, looking at people when they say, I wasn't going to sell this company or transfer this company, in order to defraud someone. It's too hard to determine that on the papers today and would violate the standards for motion for summary judgment. So that's another important consideration. But at bottom, underlying all of this, the moving party here, the opposing counsel has really failed to meet its burden. There are, as Your Honor knows, any doubts on this matter, any doubts on summary judgment should be resolved against the moving party. And we think that they just haven't fully convinced this court, and there are too many open questions remaining for a jury, and that for those reasons, summary judgment should be denied. Other than the point, Your Honor, that when we think about this at its most fundamental level, we have a consumer purchasing a car that is rife with problems and is going to be unable to claim relief because of it, because of a legal fiction, and what we see is a sort of a transferring of a corporation in a way that seems just not 100% separate, and that sets a dangerous precedent for corporations around the state.
But isn't it true as a matter of policy that corporations are permitted to exist as they try to encourage risk-taking financial ways of financing with financial liability? If constantly this policy is frustrated by continuation, how do we preserve the public policy of encouraging new enterprises and businesses?
Your Honor, I think it's a very important consideration, and something that the court should not take lightly. I do think, though, that this is not your paradigmatic situation of a corporation, creating separate entities as part of its lawful business and ordinary course of business. What we see here is a corporation being transferred to family members with questions being raised on possible lack of consideration. There's so many factors are similar that the California courts and the statutes make clear that if there is this lack of consideration, if there are these questions about shareholders wielding considerable influence and being the same individuals in the new corporation, that it actually subverts the traditional focus on corporations having limited liability. So I think this is a situation where beyond those questions, a jury should simply decide, because it may be on that margin. No, Your Honor.